Welcome, everyone, to today's training, Wills and Trusts for Busy Parents. I'm John Hardy, and I am thrilled that you're joining me today. I can promise you it will be informative and will give you an opportunity to take the steps necessary to protect your family. A little about my family. This picture was taken at my son's wedding last year at the California Botanical Gardens. My beautiful wife, Kimberly, is to my right. Also pictured are my adorable grandchildren, all of my children, their spouses, and that good-looking guy there is me. I've been an attorney for the over 20 years, and my law practices focuses on estate planning and asset protection. And we're going to talk a little bit more about that in a minute. We'll talk about my flat fee billing for estate planning. So you don't have to worry about getting zapped with some huge legal bill at the end. But again, we'll talk about more about that in a second. We are centrally located in Woodland Hills, California, in the Warner Center. And I welcome you to go to my website, johnhardylaw.com. Check it out, and you're going to find that we have only 5-star reviews from both Google and Yelp. Now, for approximately the next 30 minutes or so, I want to share with you some secrets about estate planning that I've learned over the years. And there are a lot of misconceptions out there. My goal here today is to give you the information you need so you can make the best decisions for your family's future. Whether you are 25 or 85 with only $1,000 or $1 million in the bank, everyone wants peace of mind that comes with knowing your family is going to be okay and your legacy will be preserved if you're no longer here. So estate planning is about making sure things go smoothly for your loved ones if you aren't here. Who are the people you are making big plans for right now? And do your plans include for their success in the event you're not here to share it with them? Hey, I get it. Estate planning is not all that fun to talk about. In fact, 70% of Americans have no estate plan at all. Nothing. They choose ignorance and procrastination over the decisive action to protect their families when they're going to need it the most. And now, if that's you and you're part of that 70%, then you are at the right place. Today, we're going to learn about why appointing guardians is so important. We'll talk a lot about probate court and how and why you must avoid it. And if you have no idea what probate court is, don't worry. We'll go over all of that, as well as comparing a will versus a revocable living trust. And finally, we will discuss how to protect your children from themselves if you're not here. You may not be aware of it, but everyone in California already has a default estate plan. But frankly, it is horrible. Please don't let the state of California determine what happens to your family. My law firm does estate planning so our clients can override the California default rules that are so bad. Now, I'm sure there is nothing more important to you than making sure your kids are taken care of in the manner and by the people you want to be their appointed guardians if you're not here. In California, it must be done in accordance with some very specific laws. If you do not nominate legal guardians for your children in writing, do you know who will decide what happens to them? A judge, a complete stranger, will decide who gets permanent custody of your children. I can tell you from experience, that is ugly. Your family will not like the outcome. A will is the legal document where parents nominate guardians for their minor children. Don't let your children suffer through a permanent guardian court proceeding. This kind of proceeding is rigorous, it's complicated, it's time consuming, and it's grossly expensive. Now, I hear all the time, everyone in my family would be honored to raise my children if I died. Well, quite frankly, that is the problem here. You owe it to your children to avoid family members fighting custody battles. The cost on your children's emotions is just too high, a price to pay. The custody battle is brutal on everyone, but especially on the children. This is so important. Please have an attorney draft a will that complies with California law, nominating guardians for your children. Name your first choice for guardians. If it's a couple, you want to say what happens if they get a divorce or one of them dies. You may name your sister Jennifer and her husband Tim. But if Jennifer dies, do you really want your kids being raised by Tim? Maybe you do, maybe not. Write it down and then you can list as many backups as you want. Okay, so let's talk about the assets. Who gets your money when you pass away? First of all, what are assets? Well, only really wealthy people have assets or an estate, right? No. The truth is, we all have at least some of these items listed here. You need to decide where and under what circumstances your things are to be distributed when you pass away. So let's talk about your options. Now that we've determined that you need an estate plan in California, there are really only two options: a will-based estate plan or a trust-based estate plan. And now this is a decision that everyone is going to have to make, whether you are married or single, have kids or don't have kids, regardless of how much money you have, you must decide between a will-based plan or a trust-based. The vast majority of my clients will go with a trust-based plan instead of a will. But I want to make sure you understand both options clearly. Let's look at a will. What a will accomplishes. A will is where you name guardians for your minor children. You name beneficiaries. You name an executor to wrap up all your affairs. And that sounds pretty good, right? So those are the things that a will does. But that's about it. It is far better than having nothing at all and resorting to the state of California's default plan. But it really doesn't accomplish much in terms of protecting your family from predators, creditors, lawsuits, and the government. Another thing you must understand is that a will must go through probate court before your money and assets will be distributed to your family. The probate process generally takes well over a year in California, and during that time, your family will not be allowed to use your money to pay their monthly expenses. Ouch! Now, let's briefly discuss some pretty big downsides if you have only a will. As we mentioned before, wills have to be probated after your death. A will is only effective upon your death. So what happens if you are disabled and can't pay your bills or even communicate your healthcare wishes? A will not help in any of those circumstances. And statistically speaking, many of us will become disabled at some point in our life. Each state has their own laws regarding wills. So a California will is not going to be effective in New York or Florida. So if you do a California will and then you move, it is likely that you will have to redo your entire estate plan. Most parents don't want their kids to inherit everything on the day they turn 18, when they are legally entitled to do so. Most parents want their kids to get it when they're a little more mature. And you'll need a trust to do that if that's what you want. And as I said before, most assets are outside of the reach of a will and often go unplanned for. Wills do not control most property, including retirement plans, annuities, insurance policies, and anything that's held jointly with someone else. Lastly, a will simply transfers property at the time of death. You can say, I want my money to go to my daughter when I pass away, but a will does not allow you to say, when she turns 25 and has finished college. You aren't allowed to put in any instructions or restrictions in a will for how or when the money is spent for your children and grandchildren. You'll need a trust to do that. So what is probate court anyway? Literally, probate means proving the will. Basically, the main purpose of probate is to change the title on the property you own during your life to your family upon your death. If anyone contests the will, those disputes get settled in probate court. The assets are distributed to the beneficiaries per statute. A judge oversees every aspect of the process, and you will need court permission to do anything. It's complex, and your family will hire an attorney in most instances, costing tens of thousands of dollars on average in California. Your probate court experience won't be as dramatic as "You can't handle the truth" in the film A Few Good Men, but it won't be a pleasant experience either. Court is never fun. The three big downsides to probate court: number one, it's expensive. Number two, it takes a long time. And number three, it's a very public process. Court fees, lawyer fees, executor fees, probate referee fees will all eat up anywhere from 2 to as much as 10% or more of your hard-earned money, reducing the amount that ultimately goes to your family. So this is a pretty big downside to dying with a will or dying intestate, meaning without a will. Both scenarios have to be probated. The cost of probating that will at death will be significant. It's like burning money. The second downside to probate is that it can take a long time. Your assets are frozen for the whole duration, which is a problem if you're counting on money being available for the care of your minor children's monthly expenses. And the emotional burden on your family, the process dragging out over perhaps as much as 18 months is grueling. Finally, probate court is a very public process. Few things are more private than the relationship with your family and your finances. If you die with only a will, your estate will be a matter of public record, and anyone can go down to the courthouse, find all about your business, what assets you left behind, how much they're worth, and who you left them to. You end up sharing some very personal information with anyone who cares to look. It can make your minor children vulnerable to all sorts of individuals because their names are going to be in your will right alongside with how much money they'll be inheriting when they turn 18. So let me ask you, which of these bothers you the most? The expense, the time, or the fact that it's such a public process? Now, you may be asking yourself, knowing these downsides, why would anybody draft a will? And I do get asked that question a lot. And the answer is this: anyone whose total assets combined is less than $184,500 can use probate code 890. This allows for a simplified probate process for small estates. But if your total estate, the total value of everything you own, is more than $184,500, or if you want to avoid any of those three downsides, time, money, or publicity, a will is not going to be the best choice for you. By the way, it's based on the total value. That means if your only asset is a home and it's valued at $500,000, but you have a $450,000 mortgage, the state of California values your estate at $500,000. It's not just the equity. Let's get into some nuts and bolts here. It's important to understand what a comprehensive estate plan is. I can tell you from my experience, way too many estate plans don't work when you're gone and your family needs it the most. I've seen so many poorly drafted plans that do not address the real life issues that families actually face, like blended families, children with special needs, probate avoidance, or estate tax issues. A DIY or online plan or cookie cutter, and they won't address the things that matter to you the most. You are unique. Your family needs will be different than your neighbors. Another big problem is that most estate plans are simply a last will and testament. Remember, a will guarantees your family must go through probate before they can use any of your money. Most people are very surprised to hear this. The vast majority of estates just leave money outright to their kids at 18. Often it is squandered or lost in a divorce or a lawsuit. This can be prevented with proper planning. I deal with this on a regular basis, and frankly, my experience is that most DIY or online estate plans are devastating to a family at the time they need them. Their family members are hurt by their actions instead of helped. What you need is a comprehensive estate plan. And finally, most estate plans are not updated to keep up with your life. The truth is, your life is going to change. Your family assets and family members even change, and the law will change. Your plan needs to keep up with you for the maximum benefit when you need it the most. And this is why you need to work with an experienced attorney. Now you're scratching your head wondering, if a will isn't going to accomplish my objectives, what do I need? So let's look at your options. Option number 2, a revocable living trust. And again, this is the option that 97% of my clients will choose. What is a revocable living trust? I like to say it is like a will, but on steroids. It's a document that you'll create that is similar to a will, but has the plus, plus, plus advantages. Like in a will, in a trust, you'll list the people you want inheriting your money and all your possessions when you're gone. And just like a will, the trust is revocable. That means you can change it or even revoke it entirely at any time. Your revocable living trust, or RLT, is going to have a trustee, and that's going to be you. You are in charge of both the trust document itself and the assets that go into the trust. The way that a revocable living trust, or RLT, works is this. You name, create, and sign the trust. Everything you own is now outside of the trust. You want to move your assets into the trust by retitling them, called funding the trust. Keep in mind, you still have total control over the assets in the trust. You can still use them, spend them, sell them. Nothing changes. But the benefit is everything inside the trust goes to your named beneficiaries without having to go through probate. I think this is huge, don't you agree? It's the way intelligent estate planning has been done for the last 50 plus years, and most Americans miss out on it entirely. Again, over 70% of our fellow Americans have no estate plan at all, nothing. They're just giving their money away when they die. Simply put, a trust is an agreement that spells out the rules you want followed for the assets owned by the trust when you pass away. That's it. Put it another way, a trust solves all those problems people assume are solved by a will, but in fact are not. Let me give you a real life example. We'll call him Bob. Bob has a little over $100,000 in a bank account, and Bob wants to leave this money to his son, Fred. But Bob wants some rules in place for Fred before he inherits. First, he wants Fred to be 25 years old, and he wants him to get an education. Bob isn't wealthy. He doesn't need some fancy, complicated offshore trust because he's leaving millions. Bob wants Fred to be 25 before he inherits the money, and he wants him to be educated either through college or trade school. And even though Bob doesn't have a ton of money or a complicated estate plan, Bob's going to need a trust because he wants to control how and when his son gets to inherit. A revocable living trust is the answer. And if for any reason Bob ever needs the money during his own lifetime, the trust is revocable. Let's look at another example. Rebecca, a single woman, created a will leaving everything to her daughter Linda, who is 10 years old. Rebecca owns a home that she lives in worth $500,000 and also owns a rental property worth $250,000. She also has an investment account worth $250,000, and she has an insurance policy payable to a minor. Also, she has a retirement account payable to a minor. Because California law dictates that her daughter Linda cannot inherit property and take title until she's 18 years old, these assets now have to go through probate court if Rebecca were to die. A judge controls and has to approve all of it, meaning everyone gets a piece of the pie. The attorneys, court-appointed administrator, probate referees, the government, etc., and it goes on and on. When we add all of Rebecca's assets together, the total probate estate is $2,150,000. Rebecca has been very responsible with her money. And remember how I said earlier that probate can cost as much as 2 to 10% of the total probated estate? Let's look at a mere 2%. It is always more than that in my experience, but let's look at only 2%. When Rebecca dies, her will leaves everything to her daughter Linda. Her will must go through probate court. A lawyer will be hired to help probate the will because Linda's a minor. So let's say it ends up only costing 2% of Rebecca's total estate. That's still $43,000 lost to probate. And by the way, my experience is that it'll be closer to 5%, which give or take is about $107,000. $43,000 or more will not be going to her daughter, Linda. And if the will is contested, it could easily be 10% or more. 10% is $215,000. All a will is going to do for Linda's daughter is cause her to have to go through probate. Unfortunately, this is happening to 70% of Americans who are not taking advantage of our laws in California. It happens literally every day. Another example I want to share with you, let's call them Steve and Peggy. Steve and Peggy set up a revocable living trust, and they occupy all three positions. They have total control of their assets and their trust. They act as grantors who created the trust and transferred title of their assets to the trust. They occupy the manager's role as trustees who make all the decisions over the trust assets. And finally, they are also the beneficiaries of the trust, who have the right to spend and use the trust assets any way they want. In other words, Steve and Peggy still have complete control over their assets, even though the assets are titled in the name of their trust. What does it mean to be in total control? Well, it's business as usual for Steve and Peggy. They can amend their trust or even revoke it if they want. They have all the rights to manage the property, and their income tax forms are filled out in the exact same way they're always done. And the property taxes on their home get paid in the exact same manner it always has. Because this is a revocable trust, the government ignores the trust for tax purposes and continues to tax Steve and Peggy as individuals. Okay, let's step away from the will versus trust question. By now, you've got an idea in your own mind which one you want. The second big issue I want to talk to you about is, what do you want your estate plan to accomplish? Now, one of the things that most parents want their trust to do, they want it to be sure that the money they leave their kids isn't squandered or otherwise lost in some way. Let me give you another example. Sam and Karen. They have two grown kids, Jill and Mark. Sam and Karen had a will in place when they died, but took no other steps to protect their wealth that they created during their lives. Sam and Karen leave a whopping $2 million to their children, Jill and Mark, and each of them received $1 million each. Jill is married to Jason. Jason isn't a very hard worker and doesn't do much to support the family. Jill gets her $1 million and dumps the entire thing into a joint bank account with Jason. She has just commingled the money. And when they get a divorce 5 years later, Jason is entitled to half. This is the last thing that Sam and Karen ever wanted. Half of what they earned is now going to Jill's ex-husband, Jason. Mark, on the other hand, takes his $1 million and puts it in his savings account. Mark isn't married, but he is accident prone. He leaves the water running in his bathtub and then goes out for the night. The apartment below his becomes completely flooded. His downstairs neighbor sues, and Mark loses the entire inheritance, settling the lawsuit. Again, this is the last thing that Sam and Karen ever wanted. They worked hard all their lives. And unfortunately, Mark and Jill lost it all. A revocable living trust could have avoided both of these scenarios. Think of an RLT as like a backpack. When your child starts school, they get to go pick out a backpack. And it can be any kind, any color, size. There are millions of options. Your trust is the same way. You set it up so it accomplishes what you want it to accomplish. The goal is to have your trust hold all of your assets, because then those assets will avoid probate and be distributed according to the terms of the trust when you pass away. So your trust document is like the backpack. You set it up exactly how you want it, and then you move all of your assets into the trust. When you pass away, Everything held by the trust goes to your family without any probate court involvement. So right now, all of your assets are in your name, which is not what you want in order to avoid probate. You want all your assets to be held in the name of your trust. In other words, you want your assets to be inside the trust or inside the backpack in our example. Again, funding your trust is simply changing the ownership or retitling the assets so the trust owns them instead of you. And just like this lady is putting all of her stuff into her backpack, you'll put all your stuff into your trust. A trust solves all the problems that come with a will. You won't lose 2 to 10+% of your estate in probate court. Your assets go directly to your family, not years later. And it's a totally private during your life and upon death. Some other benefits of a living trust: it's easy to amend the document as your life changes. The trust doesn't get a separate tax identity, so your income taxes don't change. Your trust covers all of your property, including beneficiary assets and jointly held assets. And it's no more difficult to create a trust and maintain it than it is a will. It's valid in all 50 states, so you won't have to redo your estate plan every time you move. And because it's a private document, nobody knows what's inside it. So it's hard to contest. So you might be wondering, if I do a revocable living trust and not a will, where will I nominate guardians? And the answer is, when you do an RLT, revocable living trust, you also get a very basic will that goes with it. It's called a pour-over will. And what it does is it pours any assets not in your trust at the time of your death into your trust. So it's like a safety net. And you may also use it to nominate guardians. So how do we ensure Mark and Jill's inheritance isn't lost to divorce, lawsuit, or bankruptcy? The solution is something called a children's trust. Think of a children's trust as a tube of toothpaste. Now, the mistake Karen and Sam made in my earlier example is they gave everything to their kids outright. Giving outright distributions to your heirs is just like squeezing all the toothpaste right out onto the counter. Once it's out, it's impossible to get it back in. The money is just out on the table and can be commingled with a spouse, lost to creditors, or spent unwisely. There is no way to get it back into the tube. And believe it or not, that's the way that almost all estate plans in America are drafted. They divide it up, they dump it out, and everyone watches it dissipate. What if you did something differently? Instead of squeezing all the assets out of the trust and giving them outright to your kids, what if we divided the shares to your children equally, but kept them inside the trust, where they could be protected? This is how a children's trust works. Each child gets their own tube of toothpaste, if you will, as their inheritance, and they can squeeze money out whenever they need it. But whatever hasn't been spent cannot be lost to divorce, creditors, or a lawsuit. You pick a trustee for the trust, or an adult child can be their own trustee, or you designate that they can be trustee at a certain age if you want. It gives your children access to their inheritance while still protecting it. So if you'd like to put these kinds of protections in place, you should set up a children's trust along with your revocable living trust. Many of our clients choose to do an RLT for probate avoidance and also a children's trust in order to protect their children's inheritance. Let's talk quickly about estate taxes. California does not have an estate tax, but estates greater than $184,500 must go through the probate process unless you have a revocable living trust. Federally, the federal estate tax exemption amount for the year 2024 is $13.61 million per individual. Estates more than $27.22 million per couple are subject to federal estate tax. Most people are not anywhere near this, but we also have planning mechanisms for our higher income earners. So how do you put an action plan in place? What are the next steps? What do you need to do? How do you make it happen? When should you get it started? And how much time is it going to take to get it done right? My estate planning process is simple. First, you must attend an educational presentation, which all of you are doing right now. Congratulations. Then we will have a peace of mind planning session, and you will decide to move forward and hire us. You'll then sign an engagement letter, and you'll schedule your design meeting and fill out our questionnaire. We'll draft your estate planning documents and send them to you for your review. If at any time during the process you have questions or decide to make changes, you only need to schedule a review appointment. And you can schedule as many as you need at no additional charge. And it can be done in person, by phone, or by Zoom. Once you've finalized your documents, you'll pick a date to sign everything. Voila! Now your estate plan is legally valid. Congratulations. You might be wondering, can I just make my own trust online? DIY is great for arts and crafts, but not so much for rewiring the electricity in your home. And it's the same for estate planning. But in this case, it won't blow up in your face. It's going to blow up in the face of your family at the time that they're going to need it the most. Estate planning should be done by an estate planning attorney committed to providing a comprehensive estate plans. Bare bones trusts are often produced by attorneys who do not focus on estate planning, or worse, non-attorneys. Or people draft them online with a one-size-fits-all plan without an attorney. Often these documents do not even comply with state law. They do not contain important personalized planning to protect you and your family. And typically they go unfunded and are never properly titled. This means the trust was set up, but the assets were never moved into the trust. Because they are not funded, the estate will still be required to go through probate. This happens far too often. It is really sad, and it completely defeats the purpose of ever setting up a living trust. A much better idea is to work with a knowledgeable lawyer, and let me tell you why. Years of experience and training giving guidance and counseling on these matters, so you can have the confidence of knowing it has been done right and your family will not have to live out the nightmare of a failed trust. Don't lose sleep wondering if you or someone else has made a huge mistake. I have litigated probate matters for years, and only the family suffers from a failed plan. Recently, I had a probate case. Clients came to me after their mother died. They had gone online and had not set up a trust properly, and so I had to probate the matter for them. They thought because their mother only had the house as her single asset that it really didn't matter. Well, it ended up costing her heirs almost $100,000, all of which could have been avoided with proper planning. If you've worked with a lawyer before, you are probably somewhat familiar with hourly billing. This means the attorney keeps track of how much time they spend on your matter in 6-minute increments usually. This can be really stressful because you have no idea how much it's going to cost you until you get that final bill. You're scared to even contact your attorney or call him or email. Also, the traditional practice of law tends to be very reactive. The problem falls into their lap and the attorney is reacting to that problem. Trying to put out a fire gets expensive when you're paying an attorney by the hour. With this type of transaction-based setup, you're just a number. Your matter starts, your matter ends, and then you don't have any ongoing guidance on how to avoid problems in the future. I flipped the traditional experience on its head. My estate planning is billed as a flat fee, agreed upon in advance by you and me. You don't have to worry about being charged for every little call and email. You may have a million questions. And I promise you, I've had that client. And it's all part of your one-time flat fee. Also, we love creating estate plans for our clients because it's very proactive. We solve problems. We're not responding to negative situations. It's all about you making sure your family won't have to deal with an expensive mess when you're gone. And we really do value relationships with our clients. We want to stay in touch with you over time because we know that your estate plan is not something you do once and then never ever think about again. Your life is going to change and the law will change. We want your plan to keep up, and we want to be your attorneys for all of it. When done properly, estate planning is asset protection and growth of your wealth, not the loss of it. Okay, let's talk about our estate plan packages. Bargains are good when you're shopping for paper towels. Estate plan is like anything else. You get what you pay for, and it's worth it to make the investment to get it done right the first time. We offer 3 levels of protection: silver, gold, and platinum. And we find that most of our clients will fall into one of these 3 categories. So you can decide which level of protection meets your family's needs. Let's talk about what comes with our revocable living trust. The gold plan comes with everything you see here for both spouses if you're married. You get a revocable living trust for that probate avoidance. You also get that pour over will. This pours into your trust at your death any asset you may have left out of your trust during your lifetime. It is also where you name guardians for your minor children. And remember how we said earlier that estate planning isn't just about planning for death, it's also about planning for your incapacity? Each spouse gets a power of attorney so you can pick someone to pay your bills and manage your accounts if you're incapacitated. Each spouse also gets a healthcare proxy, so you can pick someone to make your healthcare decisions for you if you cannot communicate them yourself. You also get a HIPAA waiver, giving your healthcare proxy permission to speak to doctors on your behalf, and a living will, which outlines your end-of-life wishes. If you have minor kids, we'll name your guardians both inside and outside your will. We'll talk about that. We include an explanation of all the documents and instructions on how to title your assets to your trust. You'll get a certified copy of your trust and instructions for your successor trustee to reference when you pass away. Finally, we prepare instructions for your loved ones relating to your burial and cremation, and we give you a binder with all your original signed documents, in addition to electronic copies of everything as well. And that allows you to email them somewhere, give them via digital assets. So this is what comes with the gold plan. The platinum plan comes with all of this, plus you get that tube of toothpaste, the children's trust. This is to keep your kids' inheritance in the family. And we do a complete review of your insurance policies and a tax-saving analysis if you desire. The platinum plan also covers your clients with multiple real estate holdings, business owners, and those of you with multiple investment portfolios. And if the silver plan is best for you because you only need a will at this time, you get the will with all of the end-of-life documents: POA, healthcare proxy, HIPAA waiver, living will, nomination of guardians, explanation of documents, final disposition instructions, portfolio binder, and electronic copies of your documents as well. I look forward to meeting with you at our individual peace of mind planning session. This meeting is the best place for you to determine which plan is right for you. We will quickly go over your assets in order to determine exactly how much money your family will save by avoiding probate. This is a private time devoted only to you, your family, and their specific needs that you face. Also, I have found that many of my clients are going to have questions between now and the peace of mind planning session. We'll answer those questions, and I will guide the conversation so we determine your unique needs. Because no 2 plans are ever exactly the same, no matter how cookie cutter online companies try and make it sound. You are unique. Your family has its own unique and special concerns. And I'd like now to open it up for questions. Remember, hopefully you've been given the information you need to make the best decisions for you and your family and the preservation of your legacy. If you know right now you are ready to get started with your estate plan, please go to my website. You'll find a white box in the middle of the page. Click on that box, schedule the free peace of mind planning session. Generally, it takes only about 15 minutes to determine exactly how much money you'll save by avoiding probate. And this information will allow you to decide which plan is right for you. And I will answer all of the questions and help guide you at every turn. Again, I want to applaud you for taking this big step and watching our entire estate planning seminar. I do hope it was helpful.